Michael Irvin just dismissed his $100 million defamation lawsuit against Marriott just hours after receiving a copy of the surveillance footage that Marriott was ordered to turn over to Irvin. In this video, we'll look at the new court filings as well as Irvin's notice of dismissal. I'll explain what is likely to happen next in this case. Last Friday, Marriott was ordered to turn over a copy of the surveillance footage showing Irvin's sole interaction with the hotel employee who has accused him of misconduct during the Super Bowl week and ultimately got him canceled from his TV coverage of the Super Bowl. On Monday, March 13th, Marriott filed a certificate of compliance with the court order and status report. Let's take a look at highlights from Marriott's status report. So here we have the certificate of compliance with court order and status report that Marriott filed on March 13th, 2023. And it states that Marriott hereby certifies that on March 10th, 2023 at approximately 4:07 p.m., it produced copies of all the video recordings in its possession to plaintiff Michael Irvin. This included the only video of which Marriott is aware showing the encounter between Irvin and the individual who reported Irvin's misconduct. On top of that, it sounds like Marriott produced a second video showing Irvin leaving the hotel in a coat and tie on the evening of February 6th, 2023. This is, of course, to refute Irvin's claim or his lawyer's claim earlier in the month that Irvin was actually evicted from the hotel, was waking up in the middle of the night or waking up in the morning from his sleep and thrown out of the hotel. It goes on to state that Marriott has been working diligently with the Phoenix Renaissance Hotel to obtain and preserve any additional relevant video footage that might exist from Irvin's February 5th and February 6th, 2023 stay at the hotel. By tomorrow, March 14th, 2023, Marriott's undersigned counsel expects to receive hard drives containing all video data the hotel has been able to pull from its CCTV video systems to date, which Marriott will then produce as soon as it receives it and marks it for production. Marriott will continue to work diligently with the hotel to ensure that it has complied with the court's orders. It sounds like Marriott is taking all of its surveillance footage from February 5th and 6th. It has identified every instance where Irvin appears on the video footage on those dates, and it's presumably going to put all of that onto a hard drive and turn it over to Irvin's lawyer if it has not already. I would expect that to also show Irvin entering elevators, leaving elevators, Irvin chatting with other fans in the hotel bar, in the lobby, Irvin checking into his hotel. It might even show guests coming into or going out of Irvin's hotel room. Just hours after Marriott produced its copy of the surveillance footage showing the interaction between Irvin and his accuser, Irvin filed a notice of dismissal dismissing his lawsuit, his entire lawsuit against Marriott. Let's take a look at Irvin's notice of dismissal here. So here we have Michael Irvin's notice of dismissal filed on March 13th, 2023. As you can see here, it states that plaintiff Michael Irvin respectfully dismisses this action without prejudice pursuant to Federal Rule of Civil Procedure 41A1AI. Let's go ahead and take a look at Federal Rule of Civil Procedure 41. So here we have Rule 41, which governs the dismissal of actions. Under the relevant subsection here, it deals with voluntary dismissals of cases by the plaintiff without a court order. That's exactly what Irvin has done in this case. It states that the plaintiff, that would be Irvin, may dismiss an action without a court order by filing a notice of dismissal before the opposing party serves either an answer or a motion for summary judgment. Marriott has neither served an answer nor a motion for summary judgment, so this subsection would apply to Irvin's case, and that's exactly what he did. But what is the effect of filing a notice of voluntary dismissal without a court order like Irvin has done? Well, in this subsection right here, it actually tells us what the effect is. It says the dismissal is without prejudice. So what exactly does that even mean? Well, without prejudice means without waiving your right to refile the claim in a new lawsuit at a later point in time. So Irvin dismissed his claim in the Texas federal court without prejudice, meaning he is free to refile that in an Arizona federal or state court. You might be wondering, why on earth did Irvin dismiss his lawsuit against Marriott? Did he see something on the surveillance footage that made him change his mind about pursuing a lawsuit against Marriott? In my opinion, that's highly unlikely. Here is what I think actually happened. From the first day that he was accused of misconduct and Marriott refused to turn over the surveillance footage to Michael Irvin, Irvin's number one goal has been to get a copy of the surveillance footage as quickly as possible so that he could show the public what the interaction with the Jane Doe defendant involved, what it looked like, and clear his name. Irvin's lawyer knew that a court in Irvin's backyard in North Texas would be far more likely to force Marriott to turn over a copy of the footage earlier than normal than a court in Arizona would. There was only one problem. Irvin's lawyer probably knew that Marriott was not subject to personal jurisdiction in Texas. That is one of the things that any lawyer, plaintiff's lawyer, checks for before you file the case. Personal jurisdiction would have required that Marriott had either been incorporated in Texas, that it had its corporate headquarters in Texas. Neither of those apply here, or that the actual alleged defamation occurred in Texas. Because none of those three factors were met, there was no personal jurisdiction in Texas, and Irvin's lawyer knew that. However, just because there's no personal jurisdiction doesn't mean the case is instantly dismissed. Because Marriott removed the case to the federal court from the state court, Marriott was implicitly submitting to the court's jurisdiction, at least until the court ruled on its motion to dismiss. The court chose to rule on Irvin's motion for early discovery of the video footage before ruling on Marriott's separate motion to dismiss for personal jurisdiction, thereby forcing Marriott to actually produce the video footage or risk being in contempt of court for disobeying twice two different court orders. Marriott did the smart thing and chose to simply submit to the court's order for the time being, produce over the footage, which it should have done to begin with. So rather than waiting for the court to dismiss Marriott, which could have taken weeks or even a few months, Irvin simply dismissed his claims without prejudice as soon as he received a copy of what he wanted all along, that surveillance footage. And of course, Marriott had to learn the hard way why you don't mess with Texas. Now, had Marriott voluntarily produced a copy of the surveillance footage to Irvin when it decided to report the allegations to the NFL and evict him from its hotel, none of this would have been necessary, and Irvin probably would have filed his lawsuit directly in Arizona at the outset of this dispute. So what happens next in this ongoing saga? First, I fully expect Irvin's lawyer to release the surveillance footage to the public any day now. He has repeatedly promised to do so, and the footage is not going to contain any surprises to Irvin's lawyer, since Irvin's lawyer viewed it for himself already and then went publicly and said, I'm going to release it to the public as soon as I get a copy of it. And second, I expect that Irvin will refile his lawsuit in Arizona federal court in the coming days. Make sure to hit that subscribe button below and turn the bell notification icon on so you don't miss any of my updates on this story. And of course, as always, thank you for watching.